The process of mortgage possession in the UK is a formal legal procedure that occurs when a borrower defaults on their mortgage repayments, and the lender seeks to reclaim possession of the property. This typically happens when the borrower is unable to make mortgage payments for a sustained period, but it involves various steps, protections, and legal considerations. Point 1. Default on mortgage payments. The process usually begins when the borrower fails to keep up with the terms of the mortgage agreement, particularly missing multiple payments. Once the borrower defaults on payments, arrears, the borrower is considered to be in arrears. The lender will usually try to contact the borrower to discuss the missed payments and to find a solution, such as restructuring the mortgage or offering temporary forbearance. Missed payments. If the arrears continue to mount over time, the lender will send reminders and may formally ask the borrower to bring the payments up to date. Point 2. Notice of arrears and default. Before a lender can take legal action, they must give the borrower notice of the arrears and that they are in default under the terms of the mortgage. Notice of arrears. The lender may send a warning notice indicating the outstanding arrears and requesting the borrower to pay. Default notice. If the borrower fails to act on the arrears notice, the lender will issue a notice of default, also known as a formal demand. This notice formally notifies the borrower that they are in breach of the mortgage contract, and the lender may take further steps if the debt is not paid. Point 3. Pre-action protocol, PAP, under UK law, specifically the pre-action protocol for possession claims in respect of residential property, lenders must follow a prescribed set of steps before initiating court proceedings. Contact with the borrower. The lender must attempt to contact the borrower to discuss the situation and explore options such as repayment arrangements or other alternatives to possession, like extending the loan or reducing payments. Mortgage rescue schemes. The lender must consider the availability of government schemes or other solutions, like a mortgage-to-rent scheme, which may allow the borrower to stay in the property as a tenant while the lender recovers the loan. Affordability assessments. Lenders are required to assess whether the borrower can afford to pay the arrears. The lender must also assess whether the borrower is experiencing financial hardship or illness and offer a repayment solution where possible. Point 4. Issuing a claim for possession. If these steps fail to resolve the issue, the lender can apply to the court for a possession order. This involves claim form. The lender submits a claim form, Form N5, to the court, requesting a possession order. Supporting documents. The lender must provide evidence of the arrears, correspondence with the borrower, and any previous attempts to resolve the issue. The court will schedule a hearing, where the borrower can present their case and potentially defend against the possession order. In some cases, the borrower may still be able to avoid eviction by negotiating a new repayment plan at this stage. Point 5. Court hearing and possession order. The court hearing will typically involve a judge reviewing the evidence presented by both the lender and the borrower. Default judgment. If the borrower does not attend the hearing or fails to present a valid defense, the judge may issue a default judgment and grant a possession order to the lender. Possession order. If the court is satisfied that the borrower is in breach of the mortgage agreement, a possession order will be issued. This order states that the borrower must vacate the property within a specific period, usually 14 to 28 days. Possession date. The court may also set a date for possession, giving the borrower a fixed period to vacate the property. Point 6. Eviction. If the borrower does not leave the property voluntarily after the possession order is granted, the lender can apply for an eviction order. Bailiffs. The lender applies to the court for bailiffs to carry out the eviction. Once granted, the court will send a bailiff to physically remove the borrower from the property. Eviction notice. The borrower will receive notice of the eviction, typically at least 14 days before the bailiffs arrive to carry out the eviction. Eviction is usually a last resort, and many lenders will work with the borrower to avoid this step, particularly if the borrower is actively engaging in negotiations. Point 7. Repossession and sale of the property. Once possession is obtained, the lender will often look to sell the property to recover the outstanding mortgage debt. Sale of the property. The lender has the right to sell the property through auction or private sale, typically at market value, in order to repay the outstanding loan. Shortfall. If the property is sold for less than the mortgage balance, this creates a shortfall, and the borrower remains liable for the remaining debt. The lender may take legal action to recover the shortfall, including seeking a county court judgment, CCJ, against the borrower. Point 8. Consumer protection measures. There are significant consumer protections in place under UK law to prevent wrongful or unjust repossession. the Financial Conduct Authority, FCA, regulates mortgage lenders and imposes strict rules on how they handle arrears and defaults. Lenders must treat customers fairly and ensure that repossession is a last resort. The Mortgage Conduct of Business (MCOB) rules. These rules require lenders to assess a borrower's circumstances thoroughly before proceeding with repossession and to consider alternatives to possession. Forbearance. Lenders are expected to show forbearance and work with borrowers who are genuinely struggling to pay due to financial hardship, illness, or other serious issues. In addition, courts will usually only grant a possession order if the lender has taken steps to try to work with the borrower to avoid repossession. The court also has discretion in the case of vulnerable borrowers, and it may grant more time for them to leave the property if necessary. 9. Alternatives to possession. While repossession is a possible outcome, it is not inevitable. Several alternatives exist. Repayment plans. The lender may agree to a new repayment schedule if the borrower can demonstrate the ability to make payments on the arrears over time. Capitalizing the arrears. The lender might agree to add the arrears to the principal balance of the mortgage and extend the loan term. Mortgage Rescue Scheme. This government scheme offers borrowers the opportunity to stay in their homes by either converting part of the mortgage debt into a government loan or by renting the home back from the government. The Mortgage to Rent Scheme. 10. Impact on credit and legal consequences. Credit rating. Repossession and any subsequent shortfall will negatively impact the borrower's credit rating, making it difficult for them to obtain credit in the future. Liability for shortfall. If the property is sold for less than the owed mortgage debt, the borrower may be liable for the difference, which can have lasting financial consequences. Conclusion. Mortgage possession in the UK is a structured legal process that allows lenders to reclaim a property when borrowers default on their mortgage obligations. It involves a series of warnings, court hearings, and opportunities for the borrower to avoid repossession through payment plans or government support. However, once possession is granted, the lender can sell the property to recover the debt, and the borrower may still be liable for any shortfall. As such, borrowers are encouraged to seek legal and financial advice early in the process to avoid repossession and its consequences.